Hello everyone, welcome to Kamadhenu Law Academy. Today we are going to discuss about contract 2. What are the learning outcomes? Contract of indemnity, introduction, section 124 of Contract Act, illustration and rights of indemnifier with case laws. See, if Contract Act you should always understand in the context of illustration. The more the illustration, the more the understanding. Okay. Next, you have contract of guarantee and surety, introduction, meaning and definition of contract of guarantee, illustrations, essentials of contract of guarantee, nature of contract of guarantee with illustration and case laws, section 126, case laws, continuing guarantee, revocation of continuing guarantee, rights against principal debtor, right against principal debtor. I think it's repeated, I'm sorry. And cases and illustration, you're going to read about surety in connected with this only. Okay. So what is indemnity? What is indemnity? What is contract of indemnity? The literal meaning, indemnity means insurance. The principle, indemnity is an obligation by a person to provide compensation for a particular loss suffered by another person. Okay. Compensation from one person to another person who has suffered loss. Okay, indemnities from the basis of many insurance contracts. For example, forms the basis of many insurance contracts. For example, a car owner may purchase different kinds of insurance as indemnity for various kinds of loss arises from operation of the car, such as damage to the car itself or the medical expenses following an accident. In an agency context, that we have literal meaning. Now we have in the context of agency, we are going to discuss about in the context of agency context. Okay, that is literal meaning. A principal may be obligated to indemnify their agent for liabilities incurred while carrying out responsibilities under the relationship, while the events are giving rise to an indemnity may be specified by contract. The actions that must be taken to compensate the injured party are largely unpredictable and the maximum compensation is often expressly limited. In the Old English law, we have derived Indian contract word from English law. So, in Old English law, what is indemnity? Indemnity was defined as a promise to save a person harmless from the consequences of an act. Such a promise can be expressed or implied from the circumstances of the case. This view was illustrated in the case of Adamson versus Jarvis. In this case, the plaintiff, an auctioneer, sold certain goods upon the instruction of a person. It turned out that the goods did not belong to the person and the true owner held the auctioneer liable for the goods. The auctioneer in turn sued the defendant for the indemnity for the loss suffered by him by acting on his instructions. It was held that since the auctioneer acted on the instructions of the defendant, he was entitled to assume that if what he did wrong was, he would be indemnified by the defendant. This gave a very broad scope to the meaning of indemnity and it included promise of indemnity due to loss caused by any cause whatsoever. Thus, any type of insurance except life insurance was a contract of indemnity. Whatever you are incurring loss except life insurance, all other insurance are your indemnities, surety, security, whatever, for compensation. Okay. However, Indian Contract Act 1872 makes the scope narrower by defining the contract of indemnity as follows. Section 124, a contract by which one party promises to save the other from the loss caused to him by the conduct of the promisor himself or by the conduct of any other person is a contract of indemnity. Illustration, A contracts to B indemnify B against the consequences of any proceedings which C may take against B in respect of certain sum of rupees 200. This is contract of indemnity. This definition provides the following essential elements. There must be a loss. There must be caused either, the loss must be caused either by the promisor or by any other person. Indemnifier is liable only for the loss. Thus, it is clear that this contract is contingent in the nature and is enforceable only when the loss occurs. Rights of indemnifier. What are his rights then? After compensating the indemnity holder, indemnifier is entitled to all the ways and means by which the indemnifier might have protected himself from the loss. Rights of indemnity holder. 125 section of Indian Contract Act defines the rights of an indemnity holder. These are as follows. The promisee, that is the indemnity holder, in the contract of indemnity, acting within the scope of his authority, is entitled to recover from the promisor, that is the indemnifier. Rights of recovering damages. All damages that he is compelled to pay in a suit in respect of any matter to which the promise of indemnity applies. Right of recovering costs. All the costs that he is compelled to pay in such a suit if in bringing or defending it, he did not contravene the orders of the promisor and has acted as it would have been prudent for him to act. Prudent means a normal person. In the absence of the contract of indemnity, in the absence of contract of indemnity also how much it has to be done, that much. Or if the promisor authorized him bringing or defending the suit. Right of recovering sums. All sums which he may have paid under the terms of a compromise in such suit. If the compromise was not contrary to the orders of the promisor and was one which would have been prudent for the promisee to make the absence of the contract of indemnity, or if the promisor authorized him to compromise the suit, some of the important conditions which he ought to follow here are, which is that as per this section, the rights of the indemnity holder are not absolute or unfettered. He must act within the authority given to him by the promisor and must not contravene to the orders of the promisor. Further, he must act with normal intelligence, caution and care with which he would act if it were no contract of indemnity. Therefore, at the same time, if he has followed the conditions of the contract, he is entitled for the benefit. So here this is important. Okay. See, he should take as if there was no contract. Like that only he should consider it. This was held in the case of United Commercial Bank versus Bank of India, AIR 1981. In the case of Supreme Court held that courts should not grant injunction restraining the performance of the contractual obligation arising out of a letter or credit or bank guarantee. If the term of the conditions have been fulfilled, it held that such loss or bank guarantees imposes on the banker an absolute obligation to pay. In case of Mohit Kumar Saha versus New India Assurance Co. AIR 1997, Calcutta High Court held that indemnifier must pay the full amount of the value of the vehicle lost to the theft as given by the survivor. Any settlement at lesser value is arbitrary and unfair and violates Article 14 of Indian Constitution. When does the commencement of liability arises? In general, as per the definition given in section 124, it looks like an indemnity holder cannot hold the indemnifier liable until he has suffered the actual loss. So essential element is only loss. Okay, if that only is not there, then it's not there. This is then great disadvantages to the indemnity holder in case where the loss is imminent and he is not in the position to bear the loss. In the celebrated case of Gajanana Moreshwar versus Moreshwar Madan, AIR 1942, Bombay High Court observed that the contract of indemnity held very little value if the indemnity holder could not enforce his indemnity until he actually paid the loss. If a suit was filed against him, he had to wait till the judgment and pay the damages upfront before suing the indemnifier. He may not be liable to pay the judgment fees and could not sue the indemnifier. Thus, it was held that if his liability has become absolute, he was entitled to get the indemnifier to pay the amount. Now, contract of guarantee and surety. Introduction, meaning definition of contract of guarantee, illustration, essentials of contract of guarantee, nature of contract of guarantee with illustration and case laws. And section 126, case laws, continuing guarantee, revocation of continuing guarantee, rights of principal debtor cases and in illustrations. Introduction. A contract to perform the promise or discharge the liability of a third person in case of his default is called contract of guarantee. A guarantee may be either oral or written. The person who gives the guarantee is called the surety. I told you we are going to connect both the topic and read. So we are reading both guarantee and surety and indemnifier. Okay, these three topics are important in unit 1, and unit 1 contains majorly this topic only. Okay. The person whose default the guarantee is given called the principal debtor. The person to whom guarantee is given is called the creditor. Okay. Meaning and definitions of contract of guarantee. A guarantee can be many things. Okay. It can be assurance of a particular outcome, or something will be performed in a specified manner. A guarantee is a way of assuming responsibility for paying another's steps or fulfilling another's responsibilities. It can also be a promise for execution, completion, or existence of something. A guarantee can also be a promise or an assurance attesting to the quality or durability of a product or service. The English law defines a guarantee as a promise to the answer for the debt, default, or miscarriage of another. Section 126 of Indian Contract Act 1872 says that a contract of guarantee is a contract to perform the promise or discharge the liability or third person in case of his default. Illustration. If A gives an undertaking stating that if 200 are lent to C by B and C does not pay, A will pay back the money. It will be a contract of guarantee. Here A is the surety, B is the principal debtor, and C is the creditor. Surety is the person who gives the guarantee, and principal debtor is the one whom guarantee is given. And the creditor is the person to whom the guarantee is given. Contract Act uses the act word surety, which is the same as guarantor, prima facie. The surety is not undertaking to perform should the principal debtor fail. The surety is undertaking to see the principal debtor does perform his part of bargain. A contract of guarantee presupposes a principal debtor or an obligation that the principal debtor has to discharge in favor of creditor. Anything done or any promise made for the benefit of the principal debtor is deemed sufficient for consideration to the surety for giving the guarantee. If it is sufficient inducement that the person for whom the surety has given guarantee has received a benefit or creditor has suffered an inconvenience. While Section 2 Clause D of Indian Contract Act 1872 says that past consideration is good consideration, illustration C of Section 127 of Indian Contract Act seems to negate these points. Those who favor the validity of the past consideration state that law is not supposed to be guided by illustration, but there have been conflicting judgment about whether past consideration is good consideration. Okay. Illustration. A sells and delivers goods to B. C afterwards without consideration agrees to pay for them in default of B. The agreement is void. The most basic function of a contract of guarantee is to enable a person to get a job, a loan, or some goods as case may be. In case a person is desirous of buying a car or hire purchase agreement by making monthly payments over a period of time, but the car dealer asks for guarantee, then someone would have to assure him that he will make the monthly payments in case of default by a person who is buying the car. Such an undertaking results in the contract of surety, ship, or guarantee. Guarantee is security in the form of right of action against a third party called the surety or the guarantor. Contract Act is nothing. Everyday life only is Contract Act. We are reading with sections. That's it. Whatever. Everything is just whatever we deal with the daily life is your Contract Act. We read it with a section. That is the difference. That's it. Okay. What are the essentials of contract of guarantee? Essentials of a valid contract. Since contract of guarantee is a species of a contract, the general principles governing contracts are applicable here. There must be a free consent, a legal objective to the contract. Though all the parties must be capable of entering into the contract, the principal debtor may be a party incompetent to contract, that is a minor can be there. This scenario is discussed later in this chapter. We are going to deal with it. Okay. A principal debt must pre-exist. A contract of guarantee seeks to secure payment of a debt. Thus, it is necessary there is a recoverable debt. There can not be a contract to guarantee a time-barred debt. Consideration received by the principal debtor is sufficient for the surety. Anything done or any promise made for the benefit of the principal debtor can be taken as sufficient consideration to the surety for giving guarantee. Nature of contract of guarantee. The contract of guarantee has to be clear. A letter clearly stating the intention of the guarantee. A transaction will go on smoothly. One will behave appropriately. Conduct himself at the workplace will suffice. But a promise to pay extra attention or care of it does not constitute a guarantee. Excuse me. In India, a contract of guarantee may be oral or written. It may even be inferred from the course of conduct of the parties concerned. Under English law, a guarantee is defined as a promise made by one person to another to be collaterally answerable for the debt, default or miscarriage of third person, and has to be in writing. There are three parties in a contract of guarantee: the creditor, the principal debtor, and the surety. In the contract of guarantee, there are two contracts: the principal contract between the principal debtor and the creditor, as well as the secondary contract between the creditor and the surety. The contract of surety is not collateral to the contract of principal debtor, but it is independent contract. Liability of the surety is secondary and arises when principal debtor fails to fulfill his commitments. Even an acknowledgement of the debt by the principal debtor will bind the surety. It is not essential that the principal contract must be place existence at the time of contract of guarantee being made. The original contract between the debtor and the creditor may be about to come into existence. Similarly, in certain situations, a surety may be called upon to pay through the principal debtor is not liable at all. For example, in case where the principal debtor is a minor, the surety will be liable through the minor, will not be personally liable. A contract of guarantee is to be enforced according to the terms of the contract. A guarantee is a contract of strictissimum juris. That means liability of the surety is limited by law. A surety is offered protection by law and is treated as favored debtor in the eyes of law. A contract of guarantee is not a contract amberium fedi. Please pronounce it by yourself. Still, the suretyship relationship is one of the trust and confidence, and the validity of the contract depends upon good faith of the creditor. However, it is not a part of the creditor's duty to inform the surety about all his previous dealings with the principal debtor. In Whites versus Laboncherry, 1858, Lord Chelmsford held that the creditor is not bound to inform the matters affecting the credit of the debtor or any circumstances unconnected with the transaction in which he is about to engage, which will render his position more hazardous. Since it is based on a good faith, a contract of guarantee becomes invalid if the guarantee is obtained from the surety by misrepresentation or concealment as given in section 142 and 143 of Indian Contract Act 1872. Illustration. A guarantees to see payment for the iron to be supplied by him to B to the amount of 2000 tons. B and C have privately agreed that B should pay 5 per ton beyond the market price. Such excess to be applied in liquidation of an old debit. This agreement is concealed from A. A is not liable as a surety, but where the suretyship is with regard to the advance to be made by a bank, the bank need not disclose past indebtedness to the surety unless it relates to the particular transaction. Under Indian Contract Act 1872, it is defined as Section 126 of Indian Contract Act. A contract of guarantee is a contract to perform the promise or to discharge the liabilities of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom guarantee is given is called creditor. A guarantee may be either oral or written. Illustration: when A promises to a shopkeeper C that A will pay the items being brought by B if B does not pay. This is a contract of guarantee. In case if B fails to pay, C can sue A to the recovery of the balance. In case of Brickhammer versus Dralnin 1704, where the court held that when two persons come to a shop, one person buys and to give him credit, the other person promises, if he does not pay, I will. This type of contractual liability undertaking to be liable for the default of another is called the contract of guarantee. In case of Swan versus Bank of Scotland 1836, it was held that the contract of guarantee is a tripartite agreement between the creditor, principal, debtor and surety. Tripartite. Three parties, like that it is. Distinct promise of surety, liability must be legally enforceable, and consideration. Section 127 clarifies this as follows. Anything done or any promises made for the benefit of the principal debtor may be sufficient consideration to the surety for giving the guarantee. The illustration for this is A agrees to sell to B certain goods if C guarantees the payment of the price of goods. C promises to guarantee the payment in consideration of A's promise to deliver goods to B. This is sufficient consideration for C's promise. A sells and delivers goods to B. C afterwards requests A to forbear to sue B for an year and promises that if A does so, he will guarantee the payment if B does not pay. The forbears to B sue B for 1 year. This is sufficient consideration for C's guarantee. A sells and delivers goods to B. Later on, C without any consideration promises to pay A if B fails to pay. The agreement is void for lack of consideration. It is pertinent to note that there is no uniformity on the issue of past consideration. In case of Allahabad Bank versus S.M. Engineering Industries 1992, Kolkata High Court, the bank was not allowed to sue the surety in the absence of any advance payment made after the date of guarantee. But in case of Union Bank versus A.P. Bhosle 1992, Maharashtra High Court, past debts were also held to be recoverable under the wide language of this section. In general, if the principal debtor is benefited as a result of guarantee, it is sufficient consideration for the subsistence of the guarantee. Okay, it should be without misrepresentation or concealment. Section 142 specifies that guarantee obtained by misrepresenting facts that are material to the agreement is invalid, and section 143 specifies that a guarantee obtained by concealing a material fact is invalid as well. Illustrations: A appoints B for collecting bills. B fails to account for some of the bills. A asks B to get guarantor for the further employment. C guarantees B's conduct, but C is not made aware of B's previous misaccounting by A. Afterwards, B defaults. C cannot be held liable. These are other examples. You can go through it. Okay. What is continuing guarantee? The word itself says it's continuing. As per section 129 of a guarantee, which Indian Contract Act, guarantee which extends to the series of transaction is called continuing. That is 1, 2, like that. A is consideration. A in consideration that B will employ C for the collection of rents of B zamindari, promises B to be responsible to the amount of 5,000 for due collection and payment by C for those rents. This is a continuing guarantee. Another example is A guarantees payment to B, a tea dealer, for any tea that C may buy from him time to time to the amount of rupees 100. Afterwards, B supplies C to T for the amount of 200 and C fails to pay. A guarantee is continuing guarantee and A is liable for rupees 100. Okay, A guarantees payment to B for 5 sacks of rice to be delivered by B to C over the period of 1 month. B delivers 5 sacks to C and C pays it for it later. Later on, B delivers 4 more sacks to C finally to pay. A's guarantee is not a continuing guarantee and he is not liable to pay for the 4 sacks. Thus, it can be seen that continuing guarantee is given to allow multiple transactions without having to create a new guarantee for each transaction. Okay, revocation. Revocation of continuing guarantee. As per section 130, a continuing guarantee can be revoked at any time by the surety by notice to the creditor. Once the guarantee is revoked, the surety is not liable for any future transaction. However, is liable for all the transactions that happened before the notice was given. Illustration: A promises to B for all the groceries brought by C for a period of 12 months. If C fails to pay in the next 3 months, C buys 2,000 worth of groceries after 3 months. A revokes the guarantee by giving a notice to B. C further purchases 1,000 rupees of groceries. C fails to pay. A is not liable for 1,000 rupees for the purchase that was made after the notice, but he is liable for 2,000 of purchase made before the notice. This illustration is based on the English case of Oxford versus Davis. In another case, Loylets versus Harper 1880, it was held that employment of a servant is one transaction. The guarantee for a servant is thus continuing guarantee and cannot be revoked as long as the servant is in the same employment. However, it is in the case of Wingland versus Death Set Corn 1919, it was held that person who guaranteed the rent payment for his servant but revoked it after the servant left his employment was not liable for the rents after revocation. A guarantees to B to the amount of 10,000 rupees that C shall pay for the bills that B may draw upon him. B draws upon C, C accepts the bill. Now A revokes the guarantee, C fails to pay the bill upon its maturity. A is liable for the amount of rupees 10,000. As per section 131, the death of the surety acts as a revocation of the continuing guarantee with regards to the future transaction if there is no contract to the contrary. It is important to note that there must not be any contract that keeps the guarantee alive even after the death. In case of Durgapriya versus Durgapada AIR 1928, Calcutta High Court held that in each case the contract of guarantee between the parties must be looked into to determine whether the contract has been revoked due to the death of the surety or not. If there is a provision that says death does not cause the revocation, then the contract of guarantee must be held to continue even after the death of the surety. What are the rights of the surety then? A contract of guarantee being a contract, all the rights that are available to the parties of the contract are available to a surety as well. The following are the rights specific to a contract of guarantee that are available to the surety. Rights of against principal debtor, right of subrogation, as per section 140, where guaranteed debt has become due or default of the principal debtor to perform a duty as taken place, the surety upon the payment or performance of all that he is liable for is invested with all the rights which the creditor has against the principal debtor. This means that the surety steps into the shoes of the creditor. Whatever rights the creditor had are now available to the surety after paying the debt. In case of Lampion Iron Ore Co. Limited, in reference that is 1927, the court has laid down that the surety will be entitled to every remedy which the creditor has against the principal debtor to enforce every surety and all means of payment to stand in the place of the creditor to have the securities transferred in his name, though there was no stipulation for that, and to avail himself of all those securities against the debtor. This right of surety stands not merely upon the contract but also upon the natural justice. Very important. Okay. Right to indemnity. As per section 145, in every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety, and the surety is entitled to recover from the principal debtor whatever sum he has rightfully paid under the guarantee, but no sums which he has paid wrongfully. B is indebted to C and A is surety for the debt. Upon the default, C sues A. A defends the suit on reasonable grounds, but it is compelled to pay the amount. A is entitled to recover from B the cost as well as the principal debt. In the same case above, if A did not have reasonable grounds for defense, A would still be entitled to recover principal debt from B, but not any other costs. A guarantees to C to the extent of rupees 2000 payment of rice to be supplied by C to B. C supplies rice to a less amount than 2000 but obtains from A payment of rupees 2000 for the rice. A cannot recover from B more than the price of the rice actually supplied. This right enables the surety to recover from the principal debtor any amount that he has paid rightfully. The concept of rightfully is illustrated in the case of Chekkara Ponnamma versus A.S. Tammaya AIR 1983. So, rightfully means what? It is explained in this case. Okay. In this case, the principal debtor died. After hire purchasing 4 motor vehicles, the surety was sued and he paid over. The surety then sued the legal representative of the principal debtor. The court required the surety to show how much amount released by selling the vehicles, which he could not show. Thus, it was held that the payment made by the surety was not proper. Right against creditor. Right to securities. As per section 141, a surety is entitled to the benefit of every security which the creditor has against the principal debtor at the time when the contract of suretyship is entered into, whether the surety knows about the existence of such security or not. And if the creditor loses or without the consent of the surety parts with such security, the surety is discharged to the extent of the value of the surety. Illustration: C advances to B his tenant 2000 on the guarantee of A. C also has further surety for 2000 by a mortgage of B's furniture. C cancels the mortgage. B becomes insolvent and C sues A on his guarantee. A is discharged on his liability to the amount of the value of the furniture. These are the other illustrations. You can go through it. This section recognizes and incorporates the general rule of equity as expounded in the case of Carithoran versus Swinburne 1807, that the surety is entitled to every remedy which the creditor has against the principal debtor, including enforcement of every security. The expression security in section 141 means all the rights which the creditor had against property at the time of the contract. Okay, this was held by the Supreme Court in the case of State of Maharashtra versus Kaluram, AIR 1967. In this case, the state had sold a lot of felled trees for a fixed price in 4 equal installments, the payment of which was guaranteed by the defendant. The contract further provided that if a default was made in the payment of installment, the state would get the right to prevent further removal of timber and thus sell the timber for the realization of the price. The buyer defaulted, but the state still did not stop him from removing further timber. The surety was then sued for the loss, but he was not held liable. It is important to note that the right to the securities arises only after the creditor is paid in full. If the surety has guaranteed only a part of the debt, he cannot claim a proportional part of the securities after paying part of the debt. This was held in the case of Govardhan Das versus Bank of Bengal, 1891. Right to set off. Right of set off. If the creditors use the surety may have benefit of the set off. If any that the principal debtor had against the creditor, he is entitled to use the defenses that the principal debtor has against the creditor. For example, if the creditor owes the principal debtor something for which the principal debtor could have counterclaim, then the surety can also put up that counterclaim. Right against co-sureties. Effect of realizing a surety as per section 138. Where there are co-sureties, a release of the creditor of one of them does not discharge the others. Neither does it free the surety so realized from his responsibility to the other sureties. A creditor can release a co-surety at his will. However, as held in the case of Sri Chanda versus Jagadish Prasad 1966, the released co-surety is still liable to the others for contribution upon default. Right to contribution. As per section 146, where two or more persons are co-sureties for the same debt jointly or severally, with or without the knowledge of each other, under the same or different contract, in the absence of any contract to the contrary, they are liable to pay an equal share for the debt or any part of it that is unpaid by the principal debtor. Illustration. A, B and C are sureties to D for the sum of rupees 30,000 lent to E. E fails to pay. A, B and C are liable to pay 1,000 rupees each. Another example is there, you can go through it. As per section 147, co-sureties who are bound in different sums are liable to pay equally as far as the limits of the respective obligations permit. Okay. Discharge of surety from liability. A surety is said to be discharged from liability when his liability comes to an end. Indian Contract Act 1872 specify the following condition in which a surety is discharged of his liability. Section 130 by notice of revocation. Section 131 by death of surety. Section 133 by variance in the terms of contract. Illustration. A becomes a surety to C for B's conduct as manager in C's bank. Afterwards, B and C contract without A's consent that B's salary shall be raised and B shall be liable for 1/4 of the losses on overdrafts. B allows a customer to overdraft and the bank loses money. A is not liable for the loss. Okay, you can go n number of illustration. Okay, it's not one or two, it's so many illustrations. See here also. C promises to lend 5,000 rupees to B on 1st March. I guarantee the repayment. C the money to B on 1st Jan. A is discharged of his liability because of the variance in as much as C may decide to be before 1st March. Okay, section 134 by discharge of principal debtor. The surety is discharged by any contract between the creditor and the principal debtor by which the principal debtor is discharged or by any action of the creditor, the legal consequences of which is discharged of the principal debtor. Illustration. A gives a guarantee to C for the goods to be delivered to B. Later on, B contracts with the C to assign his property to C in lieu of debt. B is discharged of his liability and A is discharged of his liability. Another illustrations, you can go through it. If the principal debtor is released by a compromise with the creditor, the surety is discharged. But if the principal debtor is discharged by the operation of insolvency of law, the surety is not discharged. This was held in the case of Maharashtra Seba versus Official Liquidator 1982. Section 135 by composition, extension of time or promise not to sue, a contract between the principal debtor and the creditor by which the creditor makes a composition with or promises to give time to or promises to sue the principal debtor discharges the surety unless the surety assents to such a contract. It should be noted that as per section 136, if a contract is made by the creditor with a third person to give more time to the principal debtor, the surety is not discharged. However, in the case of One Roof Jupiter Sheets versus KP Matthew AIR in 1980, it was held that the surety was not discharged when the period of limitation got extended due to the acknowledgement of debt by the principal debtor. Further, as per section 137, mere forbearance to sue or not to make use of any remedy that is available to the creditor against the principal debtor does not automatically discharge the surety. Illustration: B won't see a debt guaranteed by A. The debt becomes payable. However, C does not sue B for an year. This does not discharge A from his suretyship. It must be noted that forbearing to sue until the expiry of the period of limitation has legal consequences of discharge of principal debtor, and thus as per section 134 will cause the surety to be discharged as well. If section 134 alone stood alone, this inference was correct. However, section 137 explicitly says that mere forbearance to sue does not discharge the surety. This contradiction was removed in the case of Mahant Singh versus UBI by Privy Council. It held that failure to sue the principal debtor until recovery is banned by the period of limitation does not discharge the surety. Section 139, by imparting surety's remedy, if the creditor does not act any act that is inconsistent with the rights of the surety or omits to do an act which his duty to surety requires him to do, and eventually remedy of surety himself against the principal debtor is thereby impaired, the surety is discharged. Illustration: C contracts with B to build a ship, the payment of which is made in installments at various stages of completion. A guarantees C's performance, B prepares last two installments, A is discharge of his liability. Okay, there is another illustration. N number of illustration. You did not worry. There are so many illustration which will explain you, and it will be, if you read illustration only, you will be able to understand the context. And go through case laws also. See, I have given n number of case laws. You can go through that also. Okay. However, when the goods are merely hypothecated and are in the custody of the debtor, and if there is loss is not because of the creditor, the surety is not discharged of his liability. Then what is the extent of the surety's liability? As per section 128, the liability of the surety is coextensive with that of the principal debtor unless it is otherwise provided in the contract. Illustration: A guarantees the payment of bill by B to C. The bill becomes due, B fails to pay. A is liable to C not only for the amount of the bill but also for the interest. This is basically means that although the liability of the surety is coextensive with that of the principal debtor, he may place a limit on it in the contract. Coextensive implies the maximum extent of the possible. He is liable for the whole amount of the debt or the promises. However, when a part of debt was recovered by disposing of certain goods, the liability of the surety is also rendered by the same amount. This was held in the case of Harigopal Agarwal versus State Bank of India AIR 1956. The surety can also place conditions on his guarantee. Section 144 says that when a person gives guarantee upon a contract, that the creditor shall not act upon it until another person has joined it as co-surety. The guarantee is not valid if the co-surety does not join. In the case of National Provincial Bank of England versus Brancobury 1906, the defendant signed a guarantee which was supposed to be signed by the three other co-sureties. One of them did not sign, and so the defendant was not held liable. Similarly, a surety may specify in the contract that his liability cannot exceed a certain amount. However, when the liability is unconditional, the court cannot introduce any conditions. Okay, court cannot. Okay. Thus, in the case of Bank of Bihar versus Limited versus Damodar Prasad AIR 1969, overruled the trial courts and high court's order that creditor must first exhaust all remedies against the principal debtor before suing the surety. Thank you. Please do subscribe for our Kamadhenu Law Academy for all the notes, videos, everything. Thank you.